Welcome to Do It for the Case Law for Thursday, August 6th, 2026. Visit doitforthecaselaw.com to listen to more in-depth, per-case reporting. Today we are covering 46 federal appellate decisions across 5 reporter beats. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 19 criminal justice cases across 5 circuits. 15 were affirmed, 3 dismissed or denied without reaching the merits, and 1 was split with a partial reversal. Moving to the First Circuit. Sheriff Cooper's conviction for sex trafficking of a minor and transportation of a minor for illegal sexual activity stand, but his forced labor conviction is vacated and remanded because the court found the indictment treated alternative means as separate offenses when they should be means of a single crime. Over in the 11th Circuit, we see a split outcome where Evan Graves's plea colloquy regarding forfeiture was sufficient, but the appeal on real property substitution findings is dismissed as waived by his valid plea agreement. Aisha Cherry faces an affirmed felon in possession conviction and 120-month sentence after the court held the statute survives Second Amendment challenges for felons under binding precedent. Hector Castro's request for compassionate release is denied because his heart condition did not meet the extraordinary and compelling reason standard despite requiring surgery. Devin Cavone Randall's appeal is dismissed after appointed counsel filed an Anders brief finding no arguable issues of merit. In a civil rights case involving prison conditions, the plaintiff's access to courts claim is dismissed, but their Eighth Amendment deliberate indifference claims against unnamed defendants are reinstated because they plausibly allege specific risks like understaffing and weapons entering through work crews. Moving to the Fourth Circuit, Robert Boyd's conditional discharge under the Adam Walsh Act is revoked after the government proved his failure to comply with treatment and his serious mental illness posed a risk of sexually violent conduct. Tevon O'Shea Van Horn's methamphetamine and fentanyl conspiracy conviction stands despite a plain error challenge to his guilty plea and a 2-level premises enhancement. William Kevin Glover's multiple drug distribution convictions are affirmed after he forfeited his suppression motion by failing to object timely to the magistrate judge's recommendation. Alexander Alonzo Galindo's traffic stop was lawful because failing to stop at green lights constituted probable cause for a violation. Tyree May's sentence challenges to sentencing guidelines enhancements fail because judges may find facts affecting advisory ranges by a preponderance of the evidence. Over in the Seventh Circuit, Damon K. Wiley Jr.'s suppression motion is denied because illegal window tinting provided reasonable suspicion for the stop regardless of other alleged violations. In 2 related outcome health fraud cases, Rishi Shah and Shraddha Agarwal's convictions for mail-wire bank fraud and money laundering are affirmed after they forfeited challenges to overbroad pretrial asset freezes that prevented them from paying their chosen counsel. Thomas Duncan's 84-month sentence for wire fraud stands with enhancements for multiple bribes and a loss calculation exceeding $1.5 million. Finally, in the Eighth Circuit, Andrew Lee Hawkins receives an affirmed 300-month sentence for producing illegal images after counsel filed an Anders brief. Piotr Lanai Jones's 96-month sentence for bank fraud conspiracy is upheld despite claims of substantive unreasonableness given her leadership role in a multi-year scheme. Turner Heinbaugh's appeal is dismissed due to a valid plea agreement waiver barring challenges to his sentence. Sidney Morgan Mitten Ybarra's probation revocation and 12-month one-day prison sentence are affirmed as within statutory limits. Back to you, David.
Thanks, James. Now for civil rights and employment discrimination with Aisha.
Thanks, David. Today I have 6 cases covering the 11th, 6th, 8th, and 9th circuits. The disposition mix is 4 affirmances, 1 reversal with remand, and 1 reversal with remand in a legal malpractice matter. Moving to the 11th Circuit, 3 cases were affirmed. In Ballard against Barrett, the court held that the plaintiff failed to overcome qualified immunity by offering only vague conclusions about abstract rights rather than identifying specific precedent for her Fourth Amendment claim. In Banks against Lemons, the court ruled that judicial immunity absolutely bars claims against a judge for acts taken in her judicial capacity, even if the order allegedly violated state law or was void ab initio, because issuing an involuntary commitment order is a normal judicial function. In Caterino against Speed, the court affirmed summary judgment for officers alleging excessive force, finding that deadly force was reasonable under the Graham and Garner standards because the suspect posed an immediate threat of serious physical harm while advancing with a metal pipe. Over in the Sixth Circuit, Knoll against Challenge Manufacturing was affirmed on all employment discrimination claims. The court found the plaintiff failed to establish pretext regarding her race and sex discrimination and retaliation claims due to excessive absences and tardiness, and the hostile work environment claim was rejected for forfeiture. Moving to the Eighth Circuit, Williams against Missouri Department of Corrections was reversed and remanded. The court held that the department was entitled to sovereign immunity because alleged defects in a video monitoring system and cell window did not constitute dangerous conditions under Missouri law, as they amounted to a failure to provide preventative measures rather than physical property defects. Finally, in the Ninth Circuit, coy design against Marin lawyers was reversed and remanded. The court found genuine disputes of material fact existed regarding whether the law firm breached duties to disclose significant developments in underlying litigation and whether that conduct caused harm to the client. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering constitutional law and habeas corpus.
Thanks, David. 3 cases today in the 6th and 9th Circuits. The court reversed 1 case, affirmed 2, and issued no dismissals or remands. First, over in the 6th Circuit, the court reversed a district court's denial of qualified immunity for Officer Nathan Falk, holding that his failure to immediately respond to an inmate's complaint did not violate a clearly established constitutional right under the 8th Amendment because the law was not defined with sufficient particularity at the time. The court also affirmed the denial of federal habeas corpus relief for Demond Lyles under Section 2254, ruling that his claim regarding a breached plea agreement was procedurally defaulted and he failed to demonstrate ineffective assistance of counsel under the Strickland standard. Moving to the 9th Circuit, the court affirmed the denial of a motion to suppress evidence for Vincent Glenn Bennett, Jr., holding that a 270-day delay between seizing narcotics and applying for a search warrant was constitutionally reasonable under the 4th Amendment given the reduced possessory interest in contraband and the government's substantial interest in preventing drug distribution. Back to you, David.
Thanks, Michael. Maria has the business and civil cases.
Thanks, David. 11 cases in this block. All 11 were affirmed or dismissed with no reversals, vacators, or remands today. In the 10th Circuit, Walgreens Specialty Pharmacy was found to have owed no legal duty under Oklahoma law to fill a specific prescription before July 13, 2020, leading to an affirmance of summary judgment in Scholl v. Walgreens. One additional affirmed case from that circuit resolved a lower priority dispute. Moving to the 11th Circuit, Dish Network prevailed against Gabby Freyfra Telecenter and Planet Telecom for direct copyright infringement involving Arabic language works pushed onto their networks. The court also affirmed the dismissal of fraud claims against Lottery.com and Matthew McGahan because the complaint failed to plead the who, what, when, where, and how with the particularity required by Federal Rule of Civil Procedure 9.b. Over in the 4th Circuit, PSEG Renewable Transmission LLC was allowed access to private property for field surveys under a preliminary injunction, as the court found the company likely possessed eminent domain power under Section 1311A of the Maryland Code and that irreparable harm existed. The balance of equities and public interest also favored the injunction. The 6th Circuit affirmed a ruling allowing a bankruptcy trustee to avoid a transfer of real property from debtor Jason Wiley to his mother, Kathleen Sullivan, finding that the release of mortgage debt was not reasonably equivalent value for the conveyance under constructive fraud provisions.
In the 9th Circuit, Tower Park Properties' complaint against Fiduciary Trust International was dismissed for failure to state a claim due to lack of causation allegations. Pet Connect Rescue's judgment was affirmed on all issues in a summary disposition. Coy Design LLC secured an affirmation of a default judgment of $6,529,958.86 against attorney A. Douglas Mastriani for his 3-year failure to respond to the legal malpractice proceeding. Finally, Beyond Blonde Productions' appeal was dismissed for lack of jurisdiction because interlocutory discovery orders regarding attorney-client privilege are not final appealable orders under the collateral order doctrine. Back to you, David.
Thanks, Maria. Now Raj joins us with the latest on immigration and government law.
Thanks, David. We have 7 substantive cases from across the country today. The disposition mix includes 2 split outcomes, where courts affirmed in part and remanded 1 dismissal for mootness, and 4 denials of petitions for review. Let's begin with the split outcomes. In the 6th Circuit, the court affirmed the denial of cancellation of removal but remanded for reconsideration of voluntary departure eligibility for Newton Scott Mulama, finding the board correctly applied the hardship standard but needed to revisit the departure issue. The 8th Circuit also issued a split ruling in Restico Laxina v. Blanche, affirming the denial of a sua sponte motion to reopen but remanding on a statutory motion to reopen because the board incorrectly applied the departure bar regulation. Moving to the 10th Circuit, the court dismissed an appeal brought by Skinnell Properties versus the City of Edwardsville as moot after the city repealed and replaced the challenged ordinance while the case was pending. In the 11th Circuit, Lourdes Villanueva Quiroz versus the Attorney General faced a denial where the court found the board provided reasoned consideration regarding the inability of the Honduran government to control gang activity. The 4th Circuit denied Maria Susana Navarrete Melgar's petition, holding that defects in a notice to appear are claim processing rules subject to waiver rather than jurisdictional defects. Finally, the 9th Circuit issued 2 routine denials. Jose Sanchez Olivares was found ineligible for relief due to a 64-day confinement bar for good moral character, and José Hernandez Alvarado's asylum claims were rejected because his proposed social groups lacked particularity. Back to you, David.
That wraps up Do It for the Case Law for Thursday, August 6th, 2026. A huge thank you to our reporting team James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel. Today's docket featured 74 total opinions across the federal circuits. we saw 36 affirmances, 7 dismissals, and 3 other dispositions. The most significant developments came from a handful of reversals, vacated decisions, and remands that will shape future litigation. Several appeals were dismissed on procedural grounds without reaching the merits. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe now and follow us for tomorrow's update.